Well, my question really was not whether this website is a public accommodation. I understand that's been stipulated. That wasn't my question. What I'm trying to understand is the breadth of your argument. And what I get is that you're making a tiny sliver of an argument. So the website can put anything on its website, even something that will blatantly or subtly tell a same-sex couple, well, this is not a service that I want. They can do that. And the website can also potentially get itself out from being a public accommodation simply by reserving a degree of selectivity. That's what you've told me so
No, I don't think it's just by reserving a degree of selectivity, but I think the more selective and sort of curated the process is, it makes it less likely to be a public accommodation, as the court recognized in Fulton.
All right, let me ask you, and then I'll finish this line, some hypotheticals in a brief submitted by Josh Blackman. A Jewish man and a Jewish woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their their nuptials. No problem, okay? Another Jewish man and a Christian woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their nuptials. Big problem. Quote, many Jews consider intermarriage an existential threat to the future of Judaism. Does that website have to accept the second couple?
Again, as we talked about before, if the Jewish website designer has, very explicitly Jewish themes on the wedding, they don't need to, on the website, they don't need to take that down for the inter-religious couple that comes. But if they offer a general service to the public, they need to offer that regardless of the customer's religion.
So the fact that they offer this that this is a Jewish, that is offered mostly to Jews, that's enough to make it, or exclusively to Jews, that's enough to make it sufficiently selective to get them out from your...
No, I'm drawing a distinction between what the website designer chooses to put on the website and who the website designer sells the website to. The website designer can choose to put on their websites whatever they want, but they just can't refuse to sell, if they're a public accommodation, they can't refuse to sell that website to someone solely because of their customers or the couple's religion.
Okay, an unmarried Jewish person asks a Jewish photographer to take a photograph for his J-Date dating profile. It's a dating service, I gather, for Jewish people.
It is.
All right, maybe Justice Kagan will also be familiar with the next website I'm going to mention. So next, a Jewish person asks a Jewish photographer to take a photograph for his ashleymadison.com dating profile. I'm not suggesting, I mean, she knows a lot of things. I'm not suggesting. Okay, does he have to do it?
Well, again, it would what Colorado it depends. What Colorado looks to is what services the photographer makes available to the public. And if the photographer makes that service available to others taking pictures, for use on websites, then probably yes. But it depends on.
Okay, Justice, then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall, and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit. That black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
Yeah,
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Well, back to my black Santa example. Suppose it's a state that defines a public accommodation, prohibits a public accommodation to discriminate on the basis of political ideology. So then the picture has to be taken.
I think that is likely, those political ideology distinctions face much more difficult constitutional scrutiny, and I think are separate in kind from the kind of characteristics that we're talking about here, which are categories of invidious discrimination. I candidly think in most circumstances, political ideology did not satisfy the constitutional requirements.
So it has to satisfy a constitutional requirement? Your argument is dependent on that?
Yes. Because even under O'Brien, we have to show a basis for what we're doing.
In light of what Justice Kennedy wrote in Obergefell about honorable people who object to same-sex marriage, do you think it's fair to equate opposition to same-sex marriage with opposition to interracial marriage?
Yes, because in how the law applies, not in discussion with folks, because of course honorable people have different views on this issue. But I think when you look at what Justice Kennedy said there, the way to honor that requirement is, as this court has set forth in Fulton, in Masterpiece, of having a rigorous interrogation to make sure that there are neutral and generally applicable laws applied in fact that way, that don't single out religion. And then the very next sentence of what Justice Kennedy said in Obergefell talked about when it transformed that honest and decent disagreement transformed into enacted law and policy, the necessary consequences to put the imprimatur of the state on that exclusion. And I think if this court were to say that the imprimatur of this court would allow a web designer to say no same-sex people allowed, or allow a school photographer to say no pictures of.
Do you think Justice Kennedy would have said that that it's honorable to discriminate on the basis of race?
No, I don't think so.
Let me just give you one more hypothetical. Suppose someone offers the service of writing customized wedding vows or customized speeches to be given at a wedding by people who have an idea what they would like to say about a family member or a good friend, but they just don't feel they're very good with words. They can't put it into words. And let's say this outfit is just starting up. They don't have a lot of clients. They're sitting they're sitting by the phone and their computer waiting for somebody to show up. So they will take anybody. All right. Can they be forced to write vows or speeches that espouse things they loathe?
No, they cannot be forced to write vows or speeches that espouse things they loathe, because that's not a protected characteristic. But they cannot, I assume in your example.
Well, is the prohibition or the limitation against compelled speech limited to things that are unconstitutional?
No, I think there are.
So why does it matter?
Well, because here, things they loathe is not a protected characteristic anywhere that I know of, but on the constitutional.
Okay, it doesn't fall within.
You
say it doesn't fall within your statute, but maybe it's going to fall within the statute. It may fall within another statute.
Under any level of scrutiny here, you look at the state's compelling interest in determining the incidental burden on in our example, the vow writer's rights, and I don't know of any state that has sort of a compelled, has the same compelling interest as they do for protecting things that other people loathe as they do for sex, gender, religion discrimination. So I think it would be a different analysis.
Justice Thomas? Justice Alito?
I want to make sure I understand some of the contours of your argument. So my first question is whether you believe that speech can be compelled so long as the person who is compelled to speak is not associated with the compelled speech.
That's not the line that we draw, Justice Alito. I think we've focused on, is it being compelled pursuant to, incidental to a content-neutral regulation of conduct, as in fair, or is it not?
Well, outside of that context, in general, does the prohibition or restriction of compelled speech apply only where there is no danger of attribution?
I don't think so, no. I would imagine applying in other contexts, too.
Okay. Do you agree with Mr. Olson that a website for marriages can tailor the website in a way that makes the website unacceptable to same-sex couples?
By saying, for instance, on every website, we believe that marriage is only between one man and one woman or something like that. Yes, we do.
You believe that's permissible?
We understand that to be permissible as a matter of Colorado law, and also we think that's consistent with the way the public accommodations laws usually work.
Mr. Olson's answer to that was if a website, or part of the answer at least, was that if a website included something like that, that would cause the website to lose a significant amount of business because some opposite-sex couples wouldn't want that. But that's dependent on the views of the community about about same-sex marriages. What if it's in a community where 99% of the public agree with that view, that same-sex marriages are bad, and they're happy to have that associated with it?
So I don't think my answer changes, Justice Alito, because I think that imposing a requirement or prohibiting that inclusion on a website is directly targeting the expressive content
Isn't
of the
that
website.
kind of a silly distinction?
Justice Alito, respectfully, no, I don't think it is. I think it's one that's familiar both to public accommodations laws and to the First Amendment. So in the public accommodations context, as Mr. Olson said, you could have a store that can say, we sell products that are solely related to Judaism, and it's not likely to be appealing to Christians or Hindus, but no one thinks the store is violating the public accommodations laws unless it says no Christians or Hindus may enter, and then it is violating the public accommodations
Is there any
laws.
limit to how broadly a state can define a public accommodation? So suppose the state defines it as any business, a business that provides services to a significant portion of the public. Would that mean it can't be regarded as a public accommodations anymore?
I don't know about that line specifically, Justice Alito. I will accept the premise of the question. I do think there are limits as to how far the state can go, at least when we're talking about what's a sufficiently substantial interest to justify or to pass scrutiny under the O'Brien test.
Well, I ask this because a lot of the arguments on your side seemed to view public accommodations that if it's a public accommodations law, it's generally okay. There's no problem with it, and that's why I want to know how far that can be expanded. So some selectivity would not necessarily take a business outside of the definition of public accommodations. The same arguments would apply.
Some selectivity wouldn't take them out, but I think the farther the state wanders from the sort of traditional core of commercial establishments that hold themselves out as serving the public, the weaker the state interest is.
What about the characteristics that form the basis for an impermissible denial of service? Any limit to those?
I think they're the same answer, so not in the sense that a state can define its public accommodations laws however it wants, but yes, when it starts to bump up against the First Amendment and you're applying the O'Brien standard, protection for some characteristics, things that go beyond the traditional things like race, sex, sexual orientation, religion, those at issue here, and get out into political affiliation or,
It can't define it as political affiliation. It can't decline it to include political affiliation.
I'm not saying it can't.
Ideology.
I'm not saying it can't define it that way. I'm just saying that the interests supported by such a prohibition would be weaker than the really core ones like those that we see at issue here.
Okay, so how much selectivity do you think is required?
So that's going to be, I think, in the first instance, as a state law matter or as a constitutional sort of backstop matter, I think it's hard to give a precise answer. I think the court's opinion in Fulton gives some guidance and says more selectivity, more individualized review is less likely to be a public accommodation. And in contrast, an entity that generally holds itself out as open to the public can't escape the public accommodations laws just by imposing a discriminatory limitation or some pretense of selectivity. And I know I can't give you a bright line, but I think this is a familiar problem in public accommodations law.
I think my last question, suppose 303 Creative says that there's so much demand for our services that we have to be selective in who we choose. Would that make this case come out differently then?
I don't think so, Justice Alito. I think that a business that is open to the public and serves the public but has more business than it can handle and so has to be selective is still a public accommodation.
Thank you. see if I understand your argument. I understand you to be arguing that a website designer can put anything it wants on a standardized website, even if that includes a denunciation of same-sex marriage. Is that correct?
Yes.
So if, to pick up on Justice Kagan's hypothetical from earlier this morning, if the standard announcement is made with love by Amber, who believes that a valid marriage is a union between one man and one woman, that's okay.
If that's on every website, yes.
I mean, this is, your argument is, you're making kind of a sliver of an argument, right? What is the difference between that and what you think is a violation of your law?
Two things, Justice Alito.
I mean, you're not, that website designer is not going to be serving a same-sex couple if the website designer puts that on the website. They're turning away same-sex couples by doing that, are they not?
They're not turning away same-sex couples. They are defining they are able to choose what services they offer, and that is the service they're choosing to offer. The state does not regulate that at all. All that the state says is whatever you choose to sell.
No, I understand that. Does it make any difference in the real world as a practical matter?
It does in the real world because my second point is that a website designer like that will lose a lot of opposite-sex couples as potential clients as well, because they don't want to be seen with that message. And what the company wants to do here is take advantage of the public marketplace, of go out and sell their wares to everyone and have control over and change what they sell to different people based on the status of what they have.
Okay, yeah, I understand that. So to sell to everyone. So this goes to the interpretation of your statute, and I'm not quite clear what your position is on it. If a business provides a service that is, quote, open to the public, it's a public accommodation, right?
Yeah, you have to engage in sales or offering services to the public, yes.
Okay. So what does open to the public mean? Does that mean no selectivity whatsoever? Anybody who wants this service can get it, and maybe if there's a greater demand than the demand exceeds the supply, you've got to wait in line. But if there's any selectivity at all, they're out.
Well, again, it's not presented in this case. The way that Colorado has historically addressed that question is say, golf clubs who had limited their membership to one gender, did they make money from public coming to their courses? Did you have to be a member to dine in the restaurant, et cetera? So selectivity, as the court discussed in Fulton, certainly is a factor, but it is a fact-specific determination that awaits more facts than we have here, because
well, you should understand what your statute means. So if suppose a website designer says, I'm offering my services, but I'm in a lot of demand for my services, and I reserve the right to decide who I will provide a website for and who I will not. Is it a public accommodation then?
If that's the only factor, then yes, but it can make decisions about who to supply that aren't based on protected characteristic and choose its clientele just fine. What it can't do is say, I reserve the right to refuse service, which means in practice, I will not serve black people. But it depends on.
Okay, Justice, then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
And presumably that would be the same Ku Klux Klan outfit, regardless whether the child was black or white or any other characteristic.
Yeah, you do see a lot of black children in Ku Klux Klan outfits, right? All the time. Suppose that
Can I?
Yeah.
Yeah, is that all right?
Sure.
I have one, I hope, easy question for you, and then a more difficult question. So As I understand your argument, the kind of you can say anything you want as long as you say it to everybody, or not say anything you want as long as you don't say it to anybody. So gay couple walks in to Ms. Smith's office and says, we want a quote from Obergefell. And she says, I don't do that. That's okay with you, yes?
Yes,
Because she doesn't do it for anybody. Yeah?
correct.
Okay. Gay couple walks in and says, this is the harder one, all right? Gay couple walks in and says, I'd like the standard website, everything's standard, the kind of website we were talking about before, but I want something in addition to that. I want on the home page, the website to say, God blesses this union, all right? And Ms. Smith says, that's a problem, Ms. Smith says. And the gay couple says, well, you would say that if we were an opposite-sex couple, right? And she says, I would say that if you were an opposite-sex couple. And the gay couple says, well, what's the big deal then? I don't know. I think that kind of is different. So I'm wondering whether you think it's different.
Well, I think it's different in part because it implicates the very compelling free exercise concerns of the vendor, which aren't present in this case, right? This is just a
Yeah,
speech.
possible. I get the idea that there's a kind of religious element to it. And I wish I could think of one that didn't have that component, because I feel like there's something else going on there as well, that it is a statement of opinion about the nature of this marriage, which, in my earlier hypotheticals, I took care to remove. But now there's a kind of statement of opinion about the nature of this marriage. And unlike the kind of our story things, which is like, obviously, it's their story, it's not the designer's story, unlike that, it feels a little bit to me as though it could be a kind of third person saying God blesses this union. And who would the third person be other than the person who's put the whole websites together? So I have difficulty with that hypothetical, and I'm wondering what you think about it.
So I agree, Justice Kagan. And I think, imagine a statement that says something along the lines of, there's a dating website that meets people, and then the people that they connect through that says, this is a wonderful marriage that we support. No religion, right? And then where you have that direct speech, it does get a little trickier. But what I would say is, this is, the default rule would still apply, even though that is an edge case, I agree, because the question is, what services does the company choose to provide? And if it chooses to provide that service to some, now here it's, it may be that looking at the service is, well, I evaluate your marriage and I give it a thumbs up or a thumbs down, and assume you don't want the thumbs down on the website, so if you get a thumbs up, you get on the website. So that's a fact question. I think that would be hard. But if it was a statement that was made solely based on the status of the person seeking the website. In other words, thumbs up for all opposite-sex couples, thumbs down for same-sex couples, then it's an easier question.
Yeah.